Good morning, doctor and my fellow friends. Today, me, Emily, Ong Kai Yue, Eng Ka Yao, Avi Nasemi Suresh Baskaria, and Ili Yeno Binti Ibrahim as Group 3, we're gonna present to you guys our Criminal Law Assignment 4. So the topic of our Assignment 4 is about the analysis regarding the offense of criminal breach of trust under the Malaysian Penal Code. So without further ado, let's get started.
Hi and good day. My name is Avinashini Suresh Bhaskaran, metric number 272814. Today, I'll be the first presenter for my group who will be explaining to you the first part of our assignment, which is the introduction part. As we all know, the offense of criminal breach of trust as defined under the section 405 of Malaysian Penal Code resembles the offense of embezzlement under the English law. A reading of this section suggests the gist of the CBG is dishonest misappropriation or convention to the own use another's property, which is nothing but the offense of criminal misappropriation according to the section 403 of Malaysian Penal Code. So the only difference between the section 403 and 405 of Malaysian Penal Code in the respect of CBT is the accused is entrusted with property or with dominion or control over the property. As regards to the title itself, which is the CBT, suggests entrustment of property is an essential requirement before an offense takes place under these sections. The language used under this section 405 of Malaysian Penal Code is wider. So as we all know, the words used are in any manner entrusted with property. So the words it extends to the entrustment of all kinds, whether such as clerks, servants, business partners, or other persons that provided their holding a position of a trust. Besides that, the term which is entrusted was found in section 405 of Malaysian Penal Code governs not only the words with the property immediately following it, but also the words or with any dominion over the property. So that's all from me. Thank you, and I'll pass to the next presenter.
Section 405 of the Penal Code is the main section regarding criminal breach of trust. The first element is the prerequisite condition to establish the case of breach of trust, which is the accused shall either be entrusted with property or with any dominion over the property. The entrustment can come into existence in various forms. For instance, a person in an official or professional capacity was entrusted with money or items. Besides that, the wording of in any manner in this provision suggested that the scope of criminal breach of trust is not limited to legal transactions only, but also applies in illegal transactions. In the aspect of dominion, showing the general control over the property is sufficient as the provisions stated that either solely or jointly with another person. The principal case is Sinathambi versus PP. In this case, the appellant exercised dominance over the property as stated in his contract of service, even though he was not entrusted with the property. Moving to the second element, the act of the accused has committed dishonest misappropriation or conversions, or has either used or disposed of that property. In Jinwai versus PP, the accused borrowed the necklace and pawned the necklace. He has dishonestly misconverted the property to his own use. In regards to the third element, the provision stated that there will be a violation to the law or legal contract if the accused used or disposed the property dishonestly. For example, a civil servant who was obligated to keep the government revenue had infringed the regulation when he used the money that he entrusted with, whereas the bank manager has violated the implied legal contract which does not grant him the authority to approve the excess or withdrawal amount. According to sections 409 of the Penal Code, the measure of dishonesty is presumed to be exist until proven otherwise. Looking at the case of Suhani versus PP, the presumption was applied after the prosecution had proven its case beyond reasonable doubt against the appellant in that he had dishonestly misappropriated the money for her own use. The last element is regarding the willfully suffer or any other person so to do, which is also the measure for criminal breach of trust. The term willfully is not defined in penal code. However, by referring to the case of Yong Tok Yun, the code defined the plain meaning of willfully as more than a mere carelessness. Willfully in certain extent may be reached to the level of knowledge or awareness.
Assalamu alaikum, Binti Madam and my fellow audiences. I am Binti Ibrahim, metric number 272732, and today I will be presenting on my group's opinions on the advantages of the provision relating to criminal breach of trust. In our humble opinion, the first advantage of the provisions on criminal breach of trust is on entrustment and domain over property. In regards to CBT, entrustment should be interpreted liberally, therefore, formal trust of property is not needed. On the other hand, dominion means that there has been a general degree of control that has been given to a person over the property. In respects to the provision, the act of dishonestly misappropriating entrusted property is recognized as the difference of the provision that renders the offender liable under Section 405, which relates to criminal breach of trust, rather than under Section 403 that relates to criminal misappropriation. Hence, offenders would be liable to be punished under the heavier provisions of Section 406, 407, 408, and 409 according to the type of entrustment the person held on the property, be it as a clerk, servant, carrier, public servant, or agent. The advantage of this aspect is seen as being in favor to the owner who has entrusted the property, as the offender has a responsibility in respect to the entrustment imposed on him. Moving on, the next advantage of the provisions on criminal breach of trust is regarding the burden of proof. In regards to the mental element, the oneness of proof is reversed, hence the offender must prove to have not acted dishonestly against the public prosecutor's claim. The provisions governing this is seen under Section 409B of the Penal Code, where the presumption that the offender had acted dishonestly on the property entrusted to him would presume until proven otherwise if the physical elements of the crime were proven. The advantage of this provision is highly seen as being in favor of the prosecution, as it is the accused who will have to disprove dishonesty. Failure to do so will result in conviction. As seen from the case of Navaratnam against public prosecutor, the public prosecutor had proved that there was criminal misappropriation of the accused on the prisoner's property that has been entrusted to him. Therefore, the accused was called upon to negate the presumption of having acted dishonestly. To recap, the two advantages of the provision on criminal breach of trust, in our humble opinion, is regarding the entrustment and dominion over property, and also the burden of proving the mental element. That is all from me. I will pass the floor to the next presenter.
So good day, good doctor, and my fellow friends. My name is Emily Gansing, and my metric number is 272767. Now, I would like to talk about the loopholes of the law of the criminal breach of trust under the Malaysian Penal Code. So first of all, in our point of view, we think that one of the loopholes is the effect of the presumption. This is because the onus of proof transfer from the prosecutor to the offender, who now needs to disprove the presumption on a balance of probabilities. The offence is not a strict liability, but with the acting of the presumption of dishonesty in Section 409B, the actus reus becomes a key aspect of the offence. The case of Oi Meng Sua versus the public prosecutor illustrates the change brought by the amendment. When the actus reus is proven, it is considered that the accused acted dishonesty, and the responsibility now falls on him to demonstrate the opposite on a balance of probability. In our opinion, such actions run against the basic aspect of proof beyond a reasonable doubt, generally referred to as the innocent until proven guilty concept. Hence, the modification set an unfavorable precedent for the use of presumption in a variety of other penal code offences. Secondly, another limitation was the required penalty of whipping. The penalty of whipping in this case is distinct from the punishment of whipping in criminal situations. In the case of offenders who fall into this group, whipping shall be inflicted in the way of school discipline with a light return. It is worth noting that the mandatory whipping was inserted to suppose deter them. So, our question is, if the goal of such a penalty is deterrence, would whipping an offender with a light cane can achieve that goal? In our point of view, if a statute provides for such a penalty in order to deter criminals, the goal of deterrence will never be fulfilled if the penalty is applied in such a half-hearted way. Thirdly, another loophole is the fourth element of the use of third parties in CBT by willfully suffering is vague, and it can lead to intolerable uncertainty and significant prejudice. Although the Malaysia has judged it suitable to vary the standard requirements relating to verification of the fourth element, we do not believe that such changes are appropriate on the basis of our assessment. So that's all from me. I will pass the floor to the next presenter.
Good day to Madam and my fellow friends. My name is Nkayao and my metric number is 272807. So today I'm going to present the method to improve the law regarding criminal breach of trust, CBT. As aforementioned, CBT can be separated into three parts. First, the precondition, and dominion. Second, physical elements. And third, the foul element, which is dishonesty and willfully. So I'm here to humbly suggest several methods to improve the law for the better. First, I am of the view that a CBT by an organization or non-government organization, NGO, should be implemented to improve the law. There are several cases regarding the CBT from organization or individual by saying that they are helping others and collect the donation or funds from the public. But at the end, the public entrusted the money to the organization, but they misappropriate the money for their personal use. Therefore, we need to have a provision to govern the CBT from organization, since we entrust our money for them to help others. Secondly, the terms of dominion over property either solely or jointly might be vague in the application of law. In my opinion, it would be great if the penal code can add an illustration of partnership, dominion, or property. In the case of Haji Sahib and Shah Peril, the accused was acquitted of CBT as there was no trust proper in the partnership property. Therefore, we suggest to add an illustration to classify the terms and the application of dominion over property either solely or jointly. Thirdly, the terms of willfully is not defined in the penal code. Therefore, there are several interpretations of willfully in the law from different approaches and cause confusion to the application of the law. We suggest to quote the meaning of willfully from the case of Kang Kim Wat against public prosecutor, as the learned judge defined willfully as acting deliberately and intentionally, or with the knowledge that the consequences are likely. Thus, we believe this is the best fit meaning to interpret the meaning of willfully. And lastly, from my personal standpoint, it is a must to have a provision to prevent the wrongdoer from evading the offense by resigning themselves according to the CBT by a public servant. In the case of Azam bin Alias against public prosecutor, the plaintiff alleged that he had resigned from the position at the time of the alleged offense. Thus, Section 408 did not apply to him. The court denied their claiming as his resignation is not accepted. Therefore, the question that arises is what if his resignation is accepted? Personally speaking, it is the need to have a provision to avoid the wrongdoer resignation when CBT is investigated. So that's all for the methods to improve the law. Thank you.
Coming back to me, in a nutshell, we can conclude overall the main factor in deciding whether to take an action in criminal breach of trust, which is the offense, is by looking to whether there is any element of dishonesty in the act. Criminal breach of trust is difficult to prove in the court of law as it requires high threshold of beyond reasonable doubt. However, there is an exception. It is an accessible means to everyone as criminal breach of trust is handled by the prosecutor, and the court may order compensation for the victim. That's all from us. Thank you and have a nice day.